Welcome back to the Law School Toolbox podcast. Today, we're sharing tips for reading a case. Your Law School Toolbox hosts are Alison Monahan and Lee Burgess. That's me. We're here to demystify the law school and early legal career experience so you'll be the best law student and lawyer you can be. We're the co-creators of the Law School Toolbox, the Bar Exam Toolbox, and the career-related website Career Dicta. Alison also runs the Girls Guide to Law School. If you enjoy the show, please leave a review or rating on your favorite listening app. And if you have any questions, don't hesitate to reach out to us. You can reach us via the contact form on lawschooltoolbox.com, and we'd love to hear from you. And with that, let's get started.
Welcome back. Today's topic actually came from a listener question, so feel free to send those in. This listener asked us to clarify how to find the black letter law in a case. And although this might seem simple, as with many things, it really isn't when you first start doing it. And, for new 1Ls particularly, but really for anyone, this is a very critical skill because you spend so much time reading cases and preparing for class, and you're trying to learn really how to tell what is important about a case and why this case is even included in the casebook. And in real life, obviously, you're going to need to do this through your own legal research. So, as much as reading cases can at times be frustrating and boring, you need to know how to do it efficiently, even once you are practicing. And this is really something, this is probably not shocking to people, but particularly if you're a litigator, you're going to keep doing this. So Lee, do you remember, before we dive in, what it was like, kind of put yourself back in that beginning stages of law school to actually read these cases?
I do. I was thinking about this prepping for this podcast, and I was remembering how frustratingly slow it was to read.
Yes.
I was just like walking through taffy or something like that because the language, oftentimes in the beginning of the semester, you're also reading very old cases. So the language is very old and feels very clunky. There's often terminology that you don't really understand is term of arts. And so you're looking up things in Black's Law Dictionary or Googling them because it's really hard to figure out what's going on. There's a lot of Latin that you may have never heard of. And it's just really dense and it makes you feel like it's kind of almost an insurmountable goal to be able to read this stuff efficiently and easily.
Right, because partly it's that you don't know in the beginning what you're going to be able to skim over. So, if some Latin word comes up, any one of those words might actually be really important. So you have to look it up and be like, oh, that's what, res ipsa loquitur or whatever it means. And then you realize at some point, oh, that's actually like a really important concept that's going to keep reappearing. Other ones, they just show up and you never hear about them again. And you realize at some point, like, oh, that's just some, procedural thing I don't really need to worry about. But you don't have any way to separate this stuff out in the beginning. I definitely remember it taking forever to read. And, I remember my first day of torts, I think a professor had given us a case. It was like 1 page long and it was an old case. And we're all kind of like, this is nothing, read the case, whatever. And we spent a whole class on that 1 page.
Yeah.
So, some professors like to explain, have you read a bunch, and other ones just want to have you read a tiny little bit. Obviously those are the best classes to be in.
True.
But at the same time, it does point out kind of how much content can be in just a page or two of what you're reading.
Yeah, that's very true. And I don't think I fully appreciated when I started in law school, the fact that a case book has been edited to try and make the pieces of the cases that are left what you really need to understand. So once I started practicing or doing full legal research, when you're getting these, very long case opinions and you're reading, page after page of facts, or, you're realizing, or it's very dense and there are so many legal issues and you're really looking for your individual legal issue. It's very different than a case in a case book that has been heavily edited. So what's left, you kind of got to be able to go through.
Yeah, and I think that, this is kind of a pro and con situation. Like on the plus side, there's less to read. On the minus side, everything on that page is there for a reason. They're not, it's like you said, in a normal case, it might be 100-page opinion and you actually need 5 of those pages. But in the casebook, they've edited it down to just those 5 pages. And so, you've got to kind of think about all right, how is this organized? Why did my professor assign it? All of these things, because basically everything on that page in the casebook could potentially be important.
Yeah. If they left in a footnote, make sure you read the footnotes.
Oh, yeah. One of my professors was like a stickler on
famous
that.
Footnotes. Yeah.
He's like,
there's some really famous footnotes.
Yeah.
Footnote 4, very famous.
Yeah.
Like, if you think.
Yeah, no, it was in Fed courts, and he was always like, the footnotes are the most important part. That's where they put everything good. And, he would call it out if somebody was in class and on call and they hadn't read the footnotes.
Yeah.
You don't get to skip those.
It's so true. No, you don't get to skip them. So other than just being edited, I also think it helps to realize that case books are trying to kind of tell a legal story. They're organizing the cases in a way. So, it is important to just think about it, you're not just pulling stuff out of the air. When you do your own legal research, you're going to like toss cases to the side that are not important. But that's not how your professor may not have you read the entire casebook, but it's likely that they're trying to, if they're picking through the casebook, they're trying to tell a story about the law, and it has a plan. And so you just want to make sure that you're reading it through that lens.
Right, because, some very smart people, like lots of them have actually worked on this casebook and kind of thought about, how do we teach this area of the law through cases? I'm sure there were many, many meetings and arguments about picking this one case over this other case. So if they're in there, there's probably a reason. And I think, when you're sitting down to read a case, it can often be good to kind of ground yourself in where you are, kind of in the big picture. And you can use your syllabus to do this. You can use the headers in the book or the table of contents. You could conceivably even use a supplement, but you want to kind of have some idea, if I'm in torts, are we in the section of the book about duty, or are we the section about breach, so that you have some understanding of what you're going to be reading. Is this an expansion of something you've already been studying, or have we switched topics completely? I think having that type of context can really help people figure out, because we're not just looking for like, what is the literal rule of law here? There's a lot of other stuff going on. And so having that context, I think, can help you see like, we've switched to a totally new topic. Maybe this is laying the foundation versus we've been doing this for 2 weeks, and maybe this is some nuance that is important.
Yeah. So when you are grounding yourself about kind of where you are, you can think about, where you are in the organization of a case book. So generally, case books are kind of organized so cases are doing different things. So cases early in a chapter can sometimes be very old and even outdated law. Sometimes even I know in my contracts class, you're reading cases from like old England.
Or the property. Property is the worst.
Property, the Fox.
Yeah, the freaking Fox case. Like
the Fox case. Everybody reads
I still don't think
Fox.
I understand the Fox case.
So, some of this stuff, it's just everybody reads it. So you have to be able to laugh when somebody mentions the Fox case in real property. So you could have some old kind of original law. And then also cases early in the chapter can provide just the general rule statements, these general black letter law statements of the rule. And then you're going to have later cases probably explain how the rule is applied to different fact patterns or highlight nuances in the application. Because sometimes, especially if you're in a class which is about common law, so that cases are making the law versus a statutory class where the statutes are making the law and the cases are interpreting those statutes, you're going to have a case that like makes the law, and then that law is going to be kind of tested over and over again. And these new opinions are going to kind of shape how the law is applied. So you want to be able to understand what's the point of that case. The other thing that can come up in case books are jurisdictional splits. Sometimes not everyone agrees on how the law should be applied. There's often like a New York way to do it and a California way to do it. Right. That's one of the typical ones, or a modern way to do it and a traditional way to do it. And so sometimes cases will just be to show you that there are multiple alternatives of what law to apply. And that stuff is usually tested on your exams.
Right. And I think that's one of those areas where people sometimes just get frustrated and kind of tune out. Like, oh, why should I care if like New York does it one way and California does it the other way? Like, I'm just going to pick my favorite one. That is not a good idea. You want to understand both of them, because these are the type of things that your professor may tease out and want you to discuss on an exam, and may give you facts that could implicate one or the other, or could go either way, or may not tell you which jurisdiction you're in, or which rule they follow. So, if you're in fictional jurisdiction A and the exam says, they haven't decided which approach to take to this issue, well, that's cluing you in that you need to talk about both of them, and hopefully you paid attention.
Yep. Exactly. And that kind of stuff can also come up on these types of questions called policy questions, which they will sometimes make you argue which approach is better. You have to understand the two approaches. And oftentimes one approach benefits one type of party over another type of party. And so you have to understand the ramifications of that and argue why one is better than the other. Yeah. Professors love to test any sort of split.
Yeah, I mean, any type of, because that's just creating the ambiguity, and that's what makes it interesting. Yep. I mean, if we could just go and kind of like look up the rule, which is what some people, I think they're doing when they read a case, is like, well, I just need the rule. Well, if we could just go look it up, nobody's going to pay hundreds of dollars an hour for a lawyer to do that for them. They would just go look it up on the internet.
Right. Yeah. You have to think about like what your skill set is. And this legal analysis piece is the skill set that they're paying for in theory. So that is like what you want to focus on doing. The other thing that I think you want to keep an eye out for in cases is how different parties argue the law to match with their facts. Different professors will become more obsessed with this. I had a professor who was obsessed with this. But one of the things you're going to need to do on your exam is argue both sides, typically, of any legal issue. And cases, they do that for you. They will say, like, plaintiff's counsel argued XYZ. Defendant's counsel argued ABC, and we think ABC is right because of, EFG. I mean, that's kind of, in a very Cliff Notes version, what the cases do to explain the legal analysis. You need to understand what parties have done to use this case law to their benefit.
Right, and this will often come up in a class like crim law or something, like, well, the prosecution would make this argument, and the defense counsel might make this argument. So, you need to be cognizant of all of those arguments.
Yeah, exactly. So, when you sit down to read, you always want to keep in mind this idea of why is this case important? Why did the editors or your professor, if they wrote the casebook, include it in the casebook? What is it teaching you about the law that you don't already know? And if you can kind of ground yourself in those questions as you go into the case and after you read the case, you are going to be doing really well when you walk into class because you're going to have an understanding of what's going on. It doesn't mean that you have to have it all figured out. You can still have open questions. You can still be confused about what happened. But if you can just even understand how it fits into this larger puzzle, that's a huge step in the right direction.
Right. And sometimes people suggest even before you sit down and do your reading, if it's an area you already know something about, you've been studying for a day or two, you even maybe think like, well, what questions do I still have about this topic? Mm-hmm. And maybe these cases will answer it. It's almost like you're on a scavenger hunt. Like, well,
yep.
We didn't really talk about, like, it said, it has to be like objective, but like, what does that mean? And maybe this new case is going to give you a gloss on that. That kind of thing can make you much more engaged in your reading.
Yeah. Okay. So now just play along with us. You're sitting down, you're cracking open your case book. It's the first couple of weeks of class, and you're going to sit down to read a case. You have out your notebook or your pens or your highlighters. You're all prepared. You're going to start briefing. And you want to make sure you understand like where you're going to find the rules, the black letter law in the case. Before we dive into what we actually want you to be looking for, I want to pause here and talk a tiny bit, just a very tiny bit about briefing, because we have lots of content on this on our website and also other podcast episodes. But briefing is very important because what we're talking about here, this exercise of really understanding what's in a case, this is the stuff that goes in your brief, whether you're doing a book brief or a paper brief or a typed brief. So, Alison, can you give us a quick primer on like why we brief, or like, is there a perfect way to brief?
Well, I don't think there's one correct way to do it. I think there are a variety of ways. People should find, kind of the best balance of benefit to time for them. For me, that was book briefing, I'll admit, after they made us do one to practice. I don't think I ever did a written brief because I didn't find it was helpful enough for the time I was spending. But the idea here is essentially it's notes on a case and kind of helping you make sense of it. So, if you think about, okay, well, if I got called on in class, like, what's my professor likely to ask you about? Well, Ms. Burgess, could you recite the facts of the case? Okay. So in your brief, however you do it, you need something that is going to quickly let you see, like, as a reminder, if you read this 3 days ago, like, well, the facts of the case are X, Y, and Z. Okay, great. And then they're going to move into more like questions about, the specifics of an argument or whatever. So you kind of want to think about it, like, what are the things you might be asked about? And then also think about these questions above. of, why is this here? Why is it important? What am I taking away from it? Because these are kind of your takeaways basically from the case. And they should be condensed. Brief shouldn't be super long. It should literally be brief.
Right. And it should refresh your recollection.
Right.
You should hopefully have retained some information while you were reading, and then it's going to refresh your recollection in class. And I think that is one of the other things when people start creating, especially if you're typing a brief, like really long briefs, that cannot be used to refresh your recollection. That's just reading something else. So you want to have these so you can remember what you did before class.
Right. It might be bullet points. It might be a little picture, like something that if you get, Miss Burgess, could you please tell us the facts of this case name, and you're flipping furiously through your notes, you're like, and you come across it and you're like, oh, yes, right. This is the one about the guy who went to the hospital and whatever,
Right. Exactly. Okay, so now you're back to reading your case. You've got your briefing plan. You know how you're going to do it. So you want to find the rule because that's what everybody's told you is important, this black letter law. Well, typically, they're not going to start with that.
Right, unfortunately for you.
It doesn't say the black letter law is : that's not what they do. The rule is, it always starts with the facts. And I think one of the things that I found surprising was how long and detailed, even on an edited case, the facts can be.
Yeah, it could be like a page or more.
Yeah, it can be a lot of facts. It can be like, so-and-so is tall and had purple hair and was walking their dog and there were trees next to, I mean, it can be incredibly detailed, and sometimes none of those facts are important. So one of the things you want to look for is, what facts are important. It's important to understand the story because the facts are going to ground you in how the law will be applied, and the facts are why they're there. But you also are going to get some extra details. So you want to focus in on this idea that some facts are going to be legally significant and very important, and some aren't. But it's amazing, really, how many facts you'll get.
Right. Well, I think part of it is you have to keep in mind where these cases came from. They weren't written for law students. They were written for a case, and they were also written by judges. Think of how many thwarted English professors ended up in law school. Some of those people probably became judges. So, those people fancy this is like their opportunity to write the great American novel, but in a case format.
Yep.
So even if it's edited, you still got to work with what you have. You can't make up stuff. So,
it's so true. Yeah.
Some of them are very wordy.
And sometimes, and some of these stories are also pretty crazy. Yeah. There can be a lot of really crazy details.
And like you mentioned, and the stuff falling down, and these are, a lot of them are pretty entertaining, actually. I think they kind of get into telling the story.
Yeah. The other thing to think about, I think, from some of these fact patterns is you mentioned that a lot of these cases can be very long in real life, and they have been edited down, but sometimes the facts haven't been completely edited down. So you might be wondering, why does it matter that there were trees and there was purple hair, or whatever these detailed facts might be? They might actually be important for an issue that you're not even going to read about. True. So that's another reason why some of those details are in there, other than just people like to tell stories.
Yeah, because sometimes you can't extract the most relevant facts from the facts as described without cutting out stuff that you don't want to cut out. Yeah. So sometimes you're just stuck with the purple hair was actually related to a free speech issue that has nothing to do with what we're using this case
for. Right, exactly. But one of the things you want to think about is after they tell this sometimes long story about all of these different facts, there's typically going to be a new paragraph where they're then going to switch to talking about law. And this, I think, is just really important. Once you get used to looking for this key kind of pivot moment, that's going to help you dial in to being ready to focus on what is the law that the court is going to apply. And so it's usually its own paragraph. Sometimes it has a header, sometimes not. But there are usually kind of signals like, in California, a plaintiff may not recover for negligent infliction of emotional distress, or the modern defense of duress is. They're really going to kind of lay it out. They typically don't hide the ball. Right. It's usually right there up front.
And that's the point where if you're book briefing, you're going to switch from your green highlighter that you're highlighting the important facts with to your yellow or whatever you use to highlight rules. So there should be that moment where you're all right, got the basic background. Some of that may or may not have been relevant. Can't really tell yet. Oh, now we're into the meat.
Yeah, this is the meat. So remember, the court is going to basically have to tell you what is the rule of law that they are planning to apply to those facts to come out with an outcome. So just if you've never read a case before, this is law that was used in a fictional case from the California Performance Test back in July 2008. But I just want to read this little paragraph of law so you can get a taste of what some of these paragraphs would sound like. Under Columbia law, punitive damages are recoverable for false imprisonment when the plaintiff proves by clear and convincing evidence that the defendant has been guilty of oppression, fraud, or malice. Malice is defined as conduct which is intended by the defendant to cause injury to the plaintiff, or despicable conduct which is carried on by the defendant with a willful and conscious disregard of the rights or safety of others. Oppression is despicable conduct that subjects a person to cruel and unjust hardship in conscious disregard of that person's right. Fraud means an intentional misrepresentation, deceit, or concealment of a material fact known to the defendant with the intention on the part of the defendant of thereby depriving a person of property or legal rights or otherwise causing injury. So, you can see that just in that paragraph, which would typically be in its own paragraph, or at the beginning of this section of the case where they're kind of reviewing the law, that is basically giving you all the law that the court is going to probably apply to the fact pattern. So that is the part you circle, you star, you highlight, you write it in your brief, whatever you're doing, because that is the black letter law.
Right. And this was a very straightforward example. It may not be quite this clear, but like it often is this clear because they've got to tell you what the elements they're going to apply are. And, you know, I think if you're struggling still to find the law, you can look for things like numbered lists. You know, often the law is broken into elements, and that's a really good signal that this is the rule. And like you said, they can't really hide the ball because they've got to use something as a rule.
Right.
You know,
and usually those rules come from old cases.
Right. I mean, this is kind of the common law system. It's like, we got to find a rule from someplace.
Right. So like there's got to be a rule. There'll typically be a citation to another case. You don't need to go read that other case, but it is important to understand that in a common law system, they're going to cite back to a rule. Or if you're taking a statutory class, let's say, everyone knows my least favorite class, civil procedure, you might have a reference to a code, the civil procedure code, but then you might also have a reference to cases that have interpreted that code.
Right.
Because that's how this works. But regardless, they're going to write down and have to say, this is what we think the law is, and this is what we're going to apply in our opinion.
Right. And they'll often say something along the lines of, you know, as discussed in case name, blah, blah, blah. Malice is da, da, da. To make it sure, you know, make it clear, like, we're not just making this up, like, we got it from someplace.
Yep.
So, you know, you want to look, as you said, for those signals, because that's really cluing you in to like, all right, this is the rule. And there may be some ambiguity, you know, they may not, you know, they, as you said earlier, they may be discussing like different approaches to the rule, but they have to tell you what they're talking about at some point.
Yep, exactly. So you might be scratching your head and saying, okay, well, how do I know when they're done, like presenting the law? Well, there's going to be a shift in the opinion from where they talk about the law, and they're going to shift to applying it to the facts. And sometimes courts are even going to give you a nice signal that says, like, in this case,
right,
plaintiff argued da 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 da. Or, you know, I mean, they're going to really, they're again not hiding the ball. And we encourage our students to do this in their own exam writing. It's like to give these signals so it can be very easy to highlight when you're switching to legal analysis for your professors. Well, judges do that too. They all went to law school.
Shockingly
enough. This is how you write. I know. This is how you and their clerks write. This is what you do in practice. So you can look for those signals to see where there's been a shift. And then they're shifting to arguments or analysis outside of just statements of what is the law.
Yeah, I think people really underestimate the importance of these signals and these transitions, because that's so kind of easy to gloss over when you're looking for like the rule. But, you know, if I'm saying as a judge or as a law clerk, you know, I was a law clerk, I wrote opinions that the judge would like, you know, use to base his opinions on. And we're trying to make it clear, you know, it's like, well, in this other case, they said that this was the rule and we agree with that or don't agree with that, and here's why. And in this case, you know, we have these facts and our facts are not exactly like those. You know, we can differentiate on these blah, 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 but whatever. So it's not just like, oh, look it up, but like they, you know, they're telling you where you are in this process, basically.
Yeah. It's very true. And what I think I didn't fully appreciate when I was a younger law student or a beginning law student was that when they start talking about facts and applying those facts to law, what they're telling you are the legally significant facts, which I feel like is often left out of early law school discussions. Like, we were talking about, is purple hair legally significant? Well, the way you would know is if they talked about the purple hair.
Right.
If the court talks about the purple hair, then that is a legally significant fact. And so if you have an exam question where somebody has orange hair instead of purple hair,
or a mohawk,
then the question, or a mohawk, or braids, or this or that it's like, well, I remember that case where purple hair was important. Does the person in my fact patterns hair, is that important? Is that legally significant hair? And the way you understand that is by seeing what the court's doing with those facts. It is important to know which facts change the outcome. And that's how, your professors are going to create these fact patterns to trigger legal issues and give you stuff to argue about. So all those facts are going to be legally significant. You have to practice understanding how facts are legally significant in a case.
Right. And this is where you can kind of play with it. So, the example we're giving might sound trivial about like purple hair, but you can start thinking of situations, where maybe this was like a workplace issue or a school issue and something happened, this person was punished for having purple hair. Okay, fine.
Right. A dress code issue.
Yeah.
Yep.
And so, they resolve this however it's resolved. And then in our next hypo that you can think of, your professor might give you in class or might give you on an exam, someone was punished for something similar, like having a nose ring. How is that similar? How is it different? These are the kind of things you want to be thinking about so that you can be thinking about how you're going to use the rule, because the rules are never just like that clear cut. I mean, it might be a rule we can say, but there's always going to be some way to argue. I mean, this is what lawyers do. We argue things.
Right. Right. Even in the classes that sound like they have clear-cut rules, it's like, I can tell you what the rule for murder is, but it's more difficult than you would think to decide if something is murder.
Well, and also you're
right?
not thinking like, well, are you talking about the model penal code rule, or are you talking about the common law rule? What state are we in? What jurisdiction?
Exactly.
You might think something like you mentioned civil procedure earlier is more straightforward because they have something called the federal rules of civil procedure. We also have the federal rules of evidence. You might think you could just go look up the answer in those books. Wouldn't that be nice if you could?
Yeah.
Because you can probably quickly deduce that if we could just go look it up, we probably wouldn't have an entire class on it. So, even in those statutory-based classes, there's still like room for tons of ambiguity.
Yeah, exactly. And so, as you get better and better at reading cases, these facts will kind of really pop out to you as you read the analysis piece. And I think that's why if you do have a casebook with very lengthy fact patterns, that is the part that you can probably read a little faster to kind of ground yourself in the story. But the really important facts are going to be discussed later. And, there are going to be the facts that maybe make it into your brief or make it into the margins of like, well, it was very important that there was purple hair. It was very important. These are the things that I need to make sure if I get called on in class that I mention happened in the case.
Right. And it might be, and it was important that there was purple hair because of, what signal that was seen to be sending like in this community or whatever.
Right.
But you're right. I mean, there's kind of background facts. Like maybe it doesn't matter like what year in high school the student was, for example. But they tell you just for like, blah, blah person was a sophomore in high school, 16 years old when she went to school with purple hair. Like you can't tell yet whether it matters that she's 16, that she matters that she was in high school, that it matters it was a school, or it matters what color her hair is. But like you said, later you do know that. Like it doesn't matter if she was 16 and not 18. That's not important.
Right. Exactly. So once you kind of really get into this meat, that's the part where the court is going to discuss its reasoning. It's going to present the arguments by both sides, and it's going to basically come into a conclusion at the end, which is kind of called the holding, which is, what did they decide? Right. Who wins?
Yeah, in that case, it might be something like, well, the student was suspended and this was on her permanent record, and we have decided that, she was suspended unconstitutionally and we are going to clear her permanent record. Again, like that's not really that relevant to you. It's just kind of like, okay, great. That's how it came out. Like that's what happened in this case. But, that doesn't really roll over into like a new set of circumstances.
No, and I think when you start reading cases, I think there is this assumption that the decision of the court is the most important piece.
Right.
But oftentimes that is not why they are included in the casebook, it's often for this meaty part that leads to that decision. It's like, sure, it's like how did they get to that decision is often more important than the actual outcome.
Yeah, so I think sometimes people confuse like the black letter rules and the holding.
And
I think it's useful to kind of clarify in your head, like which one of those is which. And, your professor might ask you in class, like, and what's the holding like of this case? Who won? And you want to be able to tell them. But ultimately, that's not the most important stuff here.
Yep. Because sometimes, although, in a common law class, cases have made the law, oftentimes you're not reading the cases that made the law. They're just going to tell you the law in that, you oftentimes don't read that case. They're going to tell you the law, and then the cases you're reading are doing these nuances. They're applying the law. And so the outcome of the case is not always the black letter law.
Yeah. I mean, sometimes they won't even, edit that part out. I mean, not usually, but, there are cases I'm like, I wonder who won. And they're like, not in there.
Exactly. That's how unimportant it is.
Yeah. Totally trivial. What happened in terms of this particular person? No one cares. It was 20 years ago.
Especially because when you have these complicated cases with multiple issues, the outcome of the case could be that it was overturned on some procedural thing that's totally different.
Exactly.
It's like that. But there is still meat that makes the case worth reading.
Definitely.
So what I think is just so important at the end, when you get to the end, is to just go back again to those original questions. Why is the case important? What is it teaching me that other stuff that I've read in this casebook hasn't taught me? And so why am I spending my time doing this? And I think if you can just make that part of your habit, it's not like it's going to take any longer than reading it the first time, but you're really likely to retain so much more because you're going to understand how it fits into this kind of larger structure of how they're trying to teach you the law.
Right. I think if anything, it's going to make it faster for you because once you've identified these key things, then your brief can be really short. And so that is going to save you a lot of time because you're not writing down a bunch of crap that isn't actually helping you get to the point.
Yep. So we mentioned, when you're reading cases to prepare for class, you're on kind of this hunting expedition. You're hunting for all these
like a truffle hunter.
Yeah, exactly. So, most modern case law is pretty easy to read. They don't use the weird cryptic old school language.
And also I just want to say one thing on that point. Sometimes particularly 1Ls love to do everything in their legal Latin. I don't think that's a great idea. Just because you read something and you looked it up and then you remembered it at the time, you don't necessarily just want to dump that into your brief because probably you're going to forget what it means. And also you need to know what these things mean. And it's also just, frankly, kind of annoying to me, as a law student, when people would throw out all this legal Latin. I'm like, could you just say what you mean? Because I think, you really want to be sure you understand it, not just that you think you sound smart or important because you're using Latin terms.
Right. There are Latin terms that are parts of legal rules, and those are very important to know. But random Latin language, not really.
It's just, I just don't find it helpful for most people, to be honest. And it even will annoy some professors because they think you're just trying to show off.
Yeah. Yeah. It's totally true. So instead, focus on how kind of the more modern cases present the law. They're usually pretty easy to read. They're usually not stuffed full of Latin words that you have to look up every other word. The organization is pretty standardized that we've kind of discussed. And then you can use your briefs, whether you've written them out or done a book brief, to just help you keep an eye out for each part of the case so you can understand when you finish a case why it is important. And if you don't understand that, make sure you understand it by the end of class or go talk to your professor, because if you don't understand it at the end of class, then you missed something.
Right. And if you're doing a book brief, you'll start to pretty rapidly see the pattern of your colors should be pretty consistent throughout cases.
Yeah.
So if you find that you're randomly highlighting weird things in different places, that should be a sign to you of is this really what I think it is? Because this is not the part of the case where they should be talking about this.
Yeah, exactly. And one of your jobs is to get better and better at this. So you can do it faster and faster. In the beginning, you're going to be slower, but you're learning a skill. So it should get easier the longer you do it.
Yeah, you'll get better at it because you will have made mistakes and learned from those mistakes and moved on. And I think, we talk a lot about the growth mindset, but this is another opportunity to practice that, of course, you're not always going to get it totally right, but that's okay. You just want to be getting better.
Exactly. Well, I was actually surprised at how much I had to say about how to read a case when we sat down to answer this question. I hope people found it helpful, but I do think it is a bit of an art to efficiently read a case.
Oh, for sure.
I think it's a good thing to think about how to like really have your plan in place of how you're going to find the important stuff.
Yeah, and this is one of the things I think that differentiates like good lawyers from other lawyers is that they can go through cases really quickly, even when they're unedited, because they know kind of what they're looking for. They know where things are likely to be, because you may be having to plow through, 10 cases to find one that's like most on point. So you need to be able to do that pretty fast.
Yeah, that is very true. So practice, and you'll be one of those lawyers who gets rewarded for working quickly and efficiently.
Exactly. Like research, that's what we do.
Yep.
That's the reality. And you can apply it to lots of skills. So like other areas too, like I have friends who basically ask me questions so I can do Google research for them because I get there way faster.
It's true. Yep, it's true. All right. Well, with that, we are out of time. I hope you guys have found this helpful to dive into all of your new cases for your 1L year. If you enjoyed this episode of the Law School Toolbox podcast, please take a second to leave a review and rating on your favorite listening app. We'd really appreciate it. And be sure to subscribe so you don't miss anything. If you have any questions or comments, please don't hesitate to reach out to myself or Alison at lee@lawschooltoolbox.com or allison@lawschooltoolbox.com, or you can always contact us via our website contact form at lawschooltoolbox.com. Thanks for listening, and we'll talk soon.